Hello, this is Liz Thompson coming to you from Stites and Harbison in sunny Lexington, Kentucky, the bourbon capital of the world. I am going to talk to you today about commencement of a bankruptcy case and more particularly about Chapter 11 first day motions. Now, myself and a bunch of other experts have published a recent publication with the ABA called Surety Aspects of Bankruptcy Law. If you are interested in this topic, you should go to the ABA website and download that publication. It has a much more in-depth treatment of this topic and many others. This will be just a very basic discussion of first day motions. And that publication has a lot more discussion about that and many other aspects of bankruptcy law that are of interest to sureties. So I encourage you to go download that publication. Chapter 11 First Day Motions. Debtors require immediate orders to pay employees, pay critical vendors, maintain surety bond programs, and obtain post-petition financing and grant liens. In a Chapter 11 bankruptcy, the debtor in possession continues to operate its own business, but after it files bankruptcy, it may not have access to cash to do any of the things listed on this first slide. And the reason why it doesn't have access to capital is because it likely has a secured creditor who has a lien on all of its cash collateral. So it likely has a secured creditor that has a lien on its accounts receivable, on the funds it has on deposit under control agreements, and otherwise. And so once the bankruptcy is filed, without being able to resort to first day motions, the debtor in possession in a Chapter 11 wouldn't be able to use any of its cash collateral to do anything. And so that is the reason for first day motions. The debtor must have use of its cash collateral in order to operate its business. It must have authorization from the bankruptcy court before it can use that collateral, so it has to seek authorization. It must obtain approval of debtor in possession of credit facility. In that credit facility will give it the right to use its cash collateral and also approve a credit facility to fund the bankruptcy. And so the debtor cannot use this cash collateral, as I've described, absent the secured creditor's consent, which they are not going to give unless they have a cash collateral order, because the cash collateral order entered by the bankruptcy court is going to give the secured creditor a lot of protections it needs. And so they are going to have to move the court for use of the cash collateral and to give the secured creditor the protection, adequate protection of its interests so that it can provide the debtor in possession financing. Sureties should be concerned with first day motions. There are many things that can happen in the context of first day motions that would have a negative impact on a surety's interest. So we are talking about cash collateral orders. There are negative things that can be included in debtor in possession financing or cash collateral orders that would negatively impact a surety. For instance, a cash collateral order or a DIP financing order could grant a secured lender a super priority administrative expense that would come before any claim of the surety. And that may be a problem for the surety to the extent that premiums become due during the bankruptcy, or the surety incurs expenses related to the bankruptcy that it's entitled to an administrative expense for. The surety may have the first claim to funds as a first priority administrative expense claim, and may not want to have the secured creditor come ahead of it, as it might if the court, in connection with the DIP financing order, grants super priority administrative expense to the secured creditor. Another concern a surety should have with first day motions that are debtor in possession financing or cash collateral motions are that secured creditors are often given priming liens as part of those motions, which means that the secured creditor's lien to secure the post-petition financing can trump first priority security interest already on assets of the debtor. If a surety has, for instance, a control agreement and has first rights in cash on deposit in a collateral account, or has other cash deposits securing its surety obligations, then it would not want the secured creditor who gives debtor in possession financing to have a lien that trumped the surety's interest on that collateral. Another concern that sureties should have with first day motions is that they may need to have their own protection from the court in the form of a first day motion. Often we file emergency motions for entry of interim and final orders approving continuation of a surety bond program. That is because absent this order, the debtor, once they file bankruptcy, may not be able to continue their surety bond programs. And if they aren't able to do that, then the debtor won't be able to provide financial assurance to contract parties, state governments, regulatory agencies, and other third parties that are essential to the debtor's reorganization and without whom the debtor may not be able to operate its business. Again, without an emergency motion for entry of interim and final orders approving continuation of a surety bond program, the debtor may not be able to do things that are required to continue the debtor's bonding, and that bonding may be essential to the debtor's operations. The debtor needs to be able to pay surety bond premiums as they come due. Without a court order, they may not be able to do so. The debtor needs to continue to be able to provide the surety with collateral. Without a court order, they may not be able to do so. Finally, the debtor may very much need to renew or acquire additional bonding in order to continue operating. And without a court order, they won't be able to do so. For these reasons, we file emergency motions for entry of interim and final orders continuing the bond programs right at the beginning of a bankruptcy case. A final motion that is often filed the first day of bankruptcy cases is a critical vendor motion. Again, without getting the court's approval to pay certain parties, the debtor may not be able to do so, especially if those parties are owed for pre-petition amounts due from the debtor, which would otherwise be general unsecured claims. If they aren't paid, there are many critical vendors who would not continue doing business with the debtors, and without whom the debtors are going to be able to continue operations. For this reason, debtors frequently file critical vendor motions at the beginning of case in order to continue paying those critical vendors. The last first day motion I want to talk about is utility motions. And utility motions are necessary because without obtaining court approval, the debtor may not be able to maintain its service from utility companies like electricity, water, gas, or telecommunications, etc. A lot of times, sureties provide performance bonds for utilities, and so it may be in the surety's best interest to see that these utility motions are filed and that the court approves agreements for continued utility service to be provided to debtors. Absent such agreements, the utilities may consider the bankruptcy a default and may draw any bonds securing performance of the debtor that the utility is holding. And so in order to prevent that from happening, the surety will want to make sure that the debtor does file utility motions that will continue this service and not result in default once the bankruptcy is filed. That is the end of my summary of first day motions. Again, this is just a very basic overview of that topic. If you're interested in surety law and how it impacts bankruptcy law or vice versa, again, I encourage you to go to the ABA website and look for surety aspects of bankruptcy law for a more detailed treatment of this topic and many others related to the subject. Thank you and goodbye.